Well, it's afternoon, so good afternoon. Welcome to the session on POWs. You realize by now that we're behind schedule, so we will finish 50 minutes later than originally expected. And I'm going to be much stricter on time than Tal was, mostly because there's lunch after all, all that. I also believe that given the content of especially the first paper and the fact that we seem to have students in the room, maybe a trigger warning is in place. Some of the content will be very graphic, or might be, depending on what Oleg decides to talk about. But maybe a few words at the very beginning. I believe it was Tamar yesterday who made a comment that it seems like many areas of the law we're discussing here are unclear, or there is still some vagueness in the interpretation of the norms. This, until recently, wasn't one of those fields. The protections granted to POWs were possibly one of the very few fields of IHL which were always, or almost always, respected. And there seemed to have been a feeling that the principle or ideas of honor and chivalry required both sides of the conflict to treat the POWs humanely. And as far as I know, in vast majority of IACs, these rules were respected. This changed massively with this conflict, as you will hear from both our speakers in a minute. I'll go back to more detailed comments on the papers if we have time, but I believe that this is one of those sessions when we can expect a lot of questions, so we'll give priority to the questions from the audience. With that, our speaker is Dr. Mykola Paszkowski. He's a member of the board of the Ukrainian Association of International Law. He has taught international law, criminal procedure, and related subjects for over 20 years in Odessa. He is an advocate, and presently he is a researcher with the Akademikan Stasis Scientific Research Institute at the National Academy of Law Sciences of Ukraine. Mykola published over 80 publications on various issues of international law and domestic law. He will speak to us today about a fascinating issue of whether, and if so, how, the exchange of POWs and prisoners before the end of hostilities is influenced by the obligation to punish war crimes. The floor is yours.
Good afternoon, everybody. Many thanks to the Minerva Center. It's a wonderful team and Hebrew University for the invitation. Thanks to my colleague Dr. Gushin for raising the important topics about the prisoners of war, POW. Since 2014, the Prosecutor Office of Ukraine has registered reports that the Russian military and Russian proxy actors are violating international humanitarian law and international humanitarian rights law during the international armed conflict caused by aggression of the Russian Federation. Ukraine has an obligation to prosecute such persons under the Geneva Convention 1949. Law enforcement and prosecutors are identifying and prosecuting such persons. Sporadically, such persons also fall into Ukrainian captivity. Courts of Ukraine have already convicted many such persons for committing crimes under the Criminal Code of Ukraine, including for violating the laws and customs of war. On the other hand, Russia and its proxy capturing Ukrainian defenders and civilians. Russians often torture such persons. Therefore, since 2018, 2014, the parties of this armed conflict have been using exchange of POW. So there is a question. Can Ukraine exchange Russian prisoners of war convicted for war crimes in Ukraine if this needs to release them from serving a sentence? I apply to answer some questions. First, do states have an obligation to punish war criminals, and this obligation absolute? If this obligation is not absolute, can states exempt war criminals from serving their sentences? What is the basis for such a release? Is the exchange of prisoners of war such an acceptable basis? So first question. Do states have an obligation to punish war crimes, and is this obligation absolute? You know, in 1949, states recognized 3 obligations regarding grave breaches of the Geneva Convention. The responsibility to criminalize the grave breaches of Convention, the responsibility to search for person alleged to have committed such grave breaches, and the responsibility to bring such persons before its own courts. I believe that the first provision on the effectiveness of criminal sanction can be read as the state's obligation to apply such sanction. Otherwise, we can lose the meaning of such criminalization. Does Ukraine fulfill this obligation? Ukraine criminalized war crime under Article 438 of the Ukrainian Criminal Code as violations of the laws and customs of war. On this slide, you can see this article. You can notice the article has 2 lists of violation of IHL. The article has a list of specific violation of IHL. The article also refers to other violation of the treaty norms of international humanitarian law. This provision allows applying this article to any violation of international humanitarian law. So volume of this article, Actus Reus, is more than the list of grave breaches by Geneva Convention. It's first feature of our national legal system. First of all, I want to explain the peculiarities of criminal statistics of war crime in Ukraine. In this slide, you can see the statistic of the Prosecutor General Office on the number of registered war crimes from 2014 to 2021. What conclusion can we make from this chart? We can see that during the active stage on the occupation of parts of the territory of Ukraine in 2014 and later to 2020, prosecutor registered only 43 war crimes. But how true is that? Was the war crimes rate really that low? Dr. Ushin saw this photo. Since 2014, the Russian military and the occupation administration in Crimea and eastern Ukraine have been constantly committing war crimes against prisoners of war and civilians. On this slide, you can see a parade of prisoners of war in Donetsk in 2014. There were also many incidents of torture of civilian and unlawful detention and other violation of IHL. I'll try to explain why the number of registered war crimes is so low at this period. Since 2014, Ukrainian authorities have viewed Russian proxy actors as a terrorist, committing acts of terrorism. Therefore, since 2014, the Ukrainian authorities conducted an anti-terrorist operation. On this slide, you can see a sharp increase in the number of registered terrorist acts and the formation of terrorist group as a crime by the Criminal Code of Ukraine. If there was armed conflict, we should talk about the creation of illegal armed conflict formation and their commission of war crimes. As a result, registered war crimes by Article 438 the Criminal Code of Ukraine were few to 2019. In 2019, Ukraine authorities replaced the anti-terrorist operation with a military one in eastern Ukraine. In the same 2019, the Prosecutor General of Ukraine established the Department of War Crimes. This department and the Prosecutor Office of the Autonomous Republic of Crimea actively began to register war crimes. However, until 2022, the courts of Ukraine made only 5 sentences about war crime under Article 438 of the Criminal Code of Ukraine. After February 2022, we can see a sharp increase in the number of registered war crimes. Every day, we can see such image with currently number of registered war crimes by date on the website of the Prosecutor General Office. A little off top, yesterday Professor Sassoli said there could not so many registered war crimes during an armed conflict. But I want to draw your attention to one feature. The Ukrainian Code of Criminal Procedure requires the registration of all reports of incidents that have the characteristic of a crime. Therefore, when a prosecutor or an investigator has information that where crime may have been committed, they enter this information into unified register of pre-trial investigation and start an investigation. If later find out, if prosecutor later find out no crime was committed, he and her will close the case. In addition, as a rule, prosecutors do not know about all violations of IHL committed on the occupied territory of Ukraine or in areas of activity in military action at the moment. Therefore, the number of war crimes may be higher. So since February 2022, Ukrainian society and international community have witnessed large-scale war crimes committed by Russian military. As a result, societal demands for justice and punishment for committing war crimes have increased. On the other hand, the Russian military committed crimes against both prisoners of war and captive civilians. The mass death of prisoners of war in the Olenivka camp and the unfair trials of the prisoners of war with the death penalty execution became widely publicized. The Russian military is massively capturing civilians as hostages, including for the purpose of their further exchange. To save defenders and citizens, the Ukrainian authorities actively use the exchange of prisoners of war and civilians. But sometimes Russian parts requires transferring them Russian prisoners of war and other persons who the courts have convicted, for example, war criminals. We have next two questions. Can states exempt war criminals for serving their sentences? What is the basis for such a release? You can see the citation from the European Court of Human Rights decision in the case of Margus against Croatia. This court's opinion confirms that any release from serving a sentence of war criminal is incompatible with the obligation of the state under the Geneva Convention. But court noticed, for example, amnesty possible where there are some particular circumstances, such as reconciliations process and or a form compensation for the victim. This is important remark, in my opinion. Therefore, amnesty is a certain exceptional cases is also possible for war crimes. We will not now analyze the validity of this conclusion of the European Court. We want to gently suggest to extrapolate this conclusion to the release from serving sentences. Then such release will not contradict the norms of international law if it creates a situation of impunity in the absence of another legitimate purpose of such release. Next question: how do parties to Russian conflict against Ukraine use the exchange of POW and what drives them? From 2014, the exchange had the following general characteristics. Both combatants and civilians were exchanged. Absence of any legal regulation, sporadic character, politicization of negotiation. The participants in the exchanges were mostly citizens of Ukraine. To ensure the exchange, the President of Ukraine and Russian Federation have repeatedly used pardons. You will notice of this chart that since February 2022, some old trends is saved. The participants of the exchange are both prisoners of war and civilians. Obviously, Russian troops continued to capture civilians. You can see on this chart the number of the exchange of prisoners of war per month. So since March 2022, the exchange of prisoners of war had stayed permanent. In June, Russian troops occupied Mariupol and captured a significant part of its defenders. I think that in June, July, the mechanism of exchanging prisoners of war was reset. That's why there was a break in these months. We can summarize the features of the exchange of prisoners of war and civilians since February 2022. I will name just a few of them. I want to notice one. The release of these persons from serving sentences is not an act of mercy. It is a forced step to save the defender of Ukraine or civilian from torture of this analysis of the public discourse allows us to formulate the following hypothesis of the main motive for the widespread use to exchanges in the last stage of the armed conflict against Ukraine. You can see on slide system of this motive. I stop one motive. Indirect humanitarian motive to prevent mistreatment of enemy prisoners of war. The leadership of Ukraine actively promotes the concept of the need to increase the exchange fund. This idea encourages Ukrainian combatants not to kill captured enemy and treat them properly for use during exchanges. 5 seconds. This scheme explains a national procedure for the exchange of prisoners of war. There is coordinating headquarters for the treatment of prisoners of war in Ukraine. The coordinator headquarters receives the consents of the person to be exchanged and approves the list of such persons. The coordinating headquarters informs the Office of the Prosecutor General about the person who was being included in the list. There are 4 options for criminal proceeding. One of options, if a person is convicted, the court decided to release the person from serving a sentence. Some final conclusion. I think that leave the release the person from serving a sentence is to ensure such an exchange is a manifestation of the principle of humanity in international humanitarian law and is consistent with the state's obligations to prosecute war criminal. I hope my presentation was not mistreatment for you. Thank you very much.